Welcome to Asst College of Arts and Commerce. This is Asst Edupedia. Myself, Assistant Professor Sunil Shah. Today, I will be covering up the topic called Doctrine of Ultravirus, which is there in the class of SYBCom and SYBAF of Sem 4 of Mumbai University under the subject called Business Law. Students, I would like to inform you the doctrine means theory, ultravirus means the act which is outside the powers and authority of the directors which are laid under the Companies Act 2013. The Latin word doctrine means a theory. The concept virus, V-I-R-E-S, means beyond the power, which is outside the power, whereas intravirus means within the power. When the director acts any act outside the powers which are been given under the memorandum and articles of association is called as ultravirus. The company directors, the managing directors or the CMD has to act according to article of association, which is subordinated to MOA, that is memorandum of association. Also AOA, that is article of association, cannot contradict with MOA. So MOA is the heart or the charter of the company which has been framed, which has been constituted, and article of association is the subordinate of MOA. AOA means rules and regulations of the company, and MOA is the constitution of the company, or it is called as the charter of the company, whereas MOA is subordinate of Companies Act 2013. Students, Companies Act 2013, which should be in line with MOA. The MOA should be the subordinate of the Companies Act, and the article of association should be subordinate of MOA. The meaning of ultravirus. The doctrine of ultravirus is a fundamental law of the Indian Companies Act, whether it is Companies Act 1956 or Companies Act 2013. Students, today we are focusing on the Companies Act 2013. It lays down that if any act of the company or any contract entered by the directors or on behalf of the company is beyond the powers vested in the directors and the company by the object clause of the MOA, it is considered to be null and void. So if the director or the CMD acts any act which is beyond the MOA, that would be called as null and void. So such type of acts are not at all accepted by law. Such null and void acts, contradicts, are not equally or legally binding on the company. The term ultravirus applies to those acts that are performed beyond the legal power stipulated under the object clause of the MOA. The ultra means beyond and the virus means the powers. The term ultravirus for the company means doing of such an act which is beyond the legal power or the authority of the company. If the company performs such an act or list of not such acts which are in line with the Companies Act 1956, they are punishable under the Companies Act 2013. What does the powers of company have? The company has the power to do such acts such as authorized by the Companies Act 1956 or the Companies Act 2013. The essentials of the attainment of the objects should be specified in memorandum, and the director should act within that specified powers which are been given under MOA and AOA, and the act should be reasonable and fairly incidental to its object clause of the MOA, that is called as the act within the powers, and any acts within that powers would be called as ultravirus. Why doctrine of ultravirus? The purpose of these restrictions are the investor in the company would get to know the object in which their money is been invested, because these persons, those who are investors in the company, are not at all aware what are the objects of the company, where that money would be invested. The shareholders invest their money into the company, but they are not aware with the object clause of the company, and ensuring that the creditors, that their money which is taken care by the company are not being wasted by the unauthorized activities of the director. So director has to act within the time frame, within that stipulated conditions which are been laid by the MOA. Ultra vires act of the director would be void if any act done by the company in due course of the business which is ultra vires in nature and does not establish any legal relationship. So for the act to be intra vires, the director has to prove, or else it would be considered as ultra vires. Such act or all such acts are void from the start and cannot be ratified by the body of the shareholders and make it binding on the company. Another important point in an act which is to be considered as ultra vires must be illegal in nature. Coming to the case study under the doctrine of ultra vires, the company, the very famous case of Ritchie and company, the company entered into contract with Ritchie for financing of the construction of a railway line in Belgium. The question raised was that the contract was whether it is would be called as general contractor or it would be called as some other contract. When the matter went into the court, the judges, the House of Lords, held that the contract was ultra vires of the company and void, that not even the subsequent assent of the whole body of the shareholders could ratify them. So in this case, Ritchie and company, the directors enter into contract without taking the approval of the shareholder. But later on they went to, they called for the meeting and they wanted to approve that particular act of the director. When the matter went to the court said that such type of act which was been ratified after taking the meeting and when the act was done earlier by the directors would be called as ultra vires. The main point of the fact of the doctrine of ultra vires is that the company, being a corporate person, that is a separate legal entity, should not be mulculated, that is fined or punished for its own act or the acts done by the agent if they are acting beyond the powers which are laid out under the MOA. The case laws of National Telephonic Company versus the state Peter Port Constables, the telephone company put up the telephone wires in a certain area. The company had no power in the memorandum to put the wires therein. The defendant cut down the lines. When the matter went into the court said that such an act of laying down the lines was not at all mentioned in memorandum, hence the cutting down of line was acceptable and such an act of the director was not at all valid. It was called as null and void. In the case of the director, an act of the transaction is ultra vires. The directors cannot ratify during the meetings after the act has been conducted. If an act is within the power of the company, any irregularities may be cured by the consent of the shareholders. Examples as expressed in the Engineering Works Limited. So students, you are aware with the concept called the Ultra Vires Act. The directors has to act within the powers, and if one of the act is done which is most important, it is in the favor of the company, such act can be ratified later on if it has been approved by the shareholders, and then the same has to be informed to ROC. In case of the articles, if any act or transaction is ultra vires, the articles the company can ratify by altering the articles by a special resolution in the AGM or calling the meeting in the extraordinary general meeting. Again, if the act is done irregularly, it can be validated by the consent of the shareholders, provided it is within the powers of the company. So specifically this point has to be noted out. It has to be provided within the powers of the company. The consent of the shareholders is mandatory when such an act is in the favor of the company for the good business of the company. Coming into the concluding part of the Ultra Vires Act, if the company is performing an act which is illegal but not authorized by MOA, then such act is called as ultra vires. If the transaction is ultra vires, cannot be ratified subsequently later on if all the shareholders gives approval. If the transaction is done which is ultra vires, then the company is not bound. Then the third party cannot sue the company, then they can sue the directors personally. In such cases, the directors are personally liable for that such act. If the company has lent money to the company and the same is used for ultra vires transaction, then he cannot recover the money from the company, it has to recover personally from the directors. In such cases, the third party has to check the MOA, the Memorandum of Association, before entering into the contract. He has the only remedy to recover the goods if he is properly identifies that the goods are purchased from that said money. In that cases, only the creditors can take hold of that particular goods. So students, in this particular video, I had explained you the doctrine of ultra vires, the acts which is beyond the powers of the company. Thank you from my side.